Okay, let's start. It's 1:02. Welcome everyone. My name is Noam Peleg, and I'm a senior lecturer at the Faculty of Law and Justice at UNSW, and it's my pleasure to welcome you to this webinar. But first, I would like to start by acknowledging the Gadigal people of the Eora Nation, where my home sits on, and from this is where I'm logging in, and to extend my respect to any Aboriginal or Torres Strait Island person who is here with us today in this webinar or who is watching this recording on YouTube. And I welcome everyone to provide their acknowledgement of country at the chat function. This is the first in a series of 3 webinars that we look at different aspects of the right of children and the environment, focusing on General Comment number 26, which was published by the UN Committee on the Rights of the Child a few weeks ago and was officially launched in Geneva earlier in this week. This webinar series is another collaboration between the Diplomacy Training Program, Youth Law Australia, and Australian Lawyers for Human Rights. And I thank everyone in this organization who are involved in supporting this webinar series. It continues on our previous series of almost 20 webinars that we had in the last 3 years that speaks about a range of child rights issues, and now all of them are available on the DTP YouTube channel. In rules, before we start, this webinar is recorded, and the message just popped up on your screen. So the webinar is recorded, and it's live streamed on social media, and the recording will be made available on YouTube later. It would be great if you can have your cameras on, but your microphones off, so we can engage with one another. The chat function is available for questions and for comments, and we are aiming to have at least 30 minutes of questions dedicated after the 2 presentations that we're going to have today. On the chat, we will also post some links to various sources and documents that will be mentioned today, and all the links will also be sent to you afterwards if you have registered to this webinar and provided a valid email address. For this opening webinar, we are very excited to host Aniva Clark. Aniva will start, and then I will present an overview of some of the key issues of the new General Comment. And after these 2 presentations, as I said, we will open the floor for everyone to participate, ask questions, and provide their comment. So without further ado, let's just jump right in. And it's give me a great pleasure to welcome Aniva Clark to this webinar. Aniva is originally from Samoa, but currently studying in New Zealand. She's an environmental activist and one of the 12 youth advisors on the UN Committee on the Rights of the Child advisory team, established by the committee to facilitate youth consultation on child rights, the environment, and climate change. So Aniva, the floor is yours.
Thank you so much. Talofa lava, everyone. My name is Aniva Clark, and I'm from Samoa, and I'm a child advisor on the Children's Advisory Team supporting the Committee on the Rights of the Child for General Comment 26, which was just launched on the 18th of September in Geneva. And so a lot of my fellow child advisors were able to attend the launch, and it was such an amazing experience for them, and they have kept me updated on what has been happening, and I believe it's something amazing that they've all been able to experience. I unfortunately couldn't go due to my exams, but it's just something that is beyond a privilege to be a part of. So without further ado, as previously mentioned, General Comment 26 is authoritative guidance on how children's rights impacted by the environmental crisis and what governments must do to uphold these rights to ensure that children live in a clean, healthy, and sustainable world. For me, the General Comment is so significant, and this is because for years, the Committee on the Rights of the Child have discussed, considered, and now for the first time, are implementing clear and authoritative guidance for member states about what they must do to uphold children's rights to a clean, healthy, and sustainable environment. And it's such a crucial step forward to hold governments around the world accountable for compromising children's rights through climate ignorance as well as inaction, which is a common issue that is prevalent across governments across the world. GC 26 is a legal guidance, is a momentous achievement and defining moment for children's rights globally. It provides the 196 member states clear directions to act on the climate emergency and ensure that children's lives and our futures are protected. And I strongly believe that General Comment 26 is a product of the protests, calls, and cries for action from children around the globe, ranging from the Fridays for Future protests across Europe, and which had influenced places around the world to do the same, as well as all the workshops and the groups and the social media campaigns that young people across the world have put together, and they've band together, used the technologies that we have today to their advantage, to our advantage, and to make our voices heard, and heard by people in really powerful positions to then take their power to then implement this change. And so it is evidence, General Comment 26 is evidence that governments and stakeholders are finally listening to children's voices to take action against the climate crisis. And for children, General Comment 26, in my opinion, has broken the glass ceiling, because it leaves us in no doubt that governments are responsible and accountable to stop the violation of children's environmental rights caused by the climate emergency. And while General Comment 26 is for children, it is also by children. So being able to work in the Children's Advisory Team, I've been able to see how much children's voices have been incorporated into the formation and the advisory, as well as the finalization of General Comment, and how significant and on the forefront it is in the development of it, because it's not something that's been left to the adults to figure out. It's been very much incorporating children because it is for children, and so therefore it's also by children, with how much input we have had. And so our participation in the development of General Comment 26 has been crucial to ensure it accurately addresses what we know are key areas for urgent action, because as children, we are the ones that see how environmental issues are compromising our rights. And so being able to have our opinions heard, people in these powerful positions are able to implement what we see as problems into the General Comment. And so this has partly been achieved through the Children's Advisory Team, as I previously mentioned, made up of 12 youth from across the world. And so we range in ages from 11 to 17 years old. So I'm 17 years old, but we have some other members of the team that are a lot younger, and they are so passionate, and I really, really admire the work they're doing, as well as the knowledge that they bring from the various regions of the world that we are from. And it's this, the consultations with young people have also been achieved through the various consultations, as well as meetings and workshops that have been done with children. And so now we have had 16,300 children as we reach the end of General Comment that has now been finalized and launched. By the end of it, we had 16,300 children. And the most significant part of this for me is that all these children came from over 120 countries. And so that just shows how much of a range of voices and opinions, as well as just the contrast of how the climate crisis and environmental issues compromise children's rights depending on what region of the world they are from. And it looks at the different, it's able to consider people that come from different backgrounds and different situations. And so it's able to ensure that children's rights, it covers enough for all children depending on their circumstances, and it truly represents the views of children. And so the committee has heard directly from children, and they understand how environmental harm and climate change are impacting us now from a first-hand perspective. And so, as I previously mentioned, the huge amount of child participation in these consultations provided a wide range of viewpoints and ideas, which once again, I believe is really, really important whenever it comes to any sort of issue that is trying to be addressed. It's the contrast of perspectives and ideas that enable to ensure that it's accurate and addresses everyone's situations. And so there was although there was a lot of contrast in these perspectives and ideas and how climate change impacts children in different places of the world, there was a strong central theme that children of the world are calling for action. Every single child pretty much that answered that said they know climate change is an issue, and they can personally see it in their everyday lives, whether that's ranging from sea level rise to temperature increasing and loss of biodiversity. It's all connected, and children are feeling the effects. And so with this, they all were calling for action and are demanding that governments address the climate crisis now. And to me, that just shows what a strong generation that is coming, because we all see that this is an issue and it's a key issue that we need to face. And as we start emerging into the future leaders and politicians and scientists and people that are in the leadership positions that are going to be making these changes, and that, because at the end of the day, I personally believe that it's the people that have the power. And so with these perspectives and this understanding of the importance of the environment, we will be able to make a change in how we address the climate crisis, which lots of young people today don't think is being addressed enough by governments currently. And so therefore, for me, General Comment 26 opens a new door for children to hold governments accountable for compromising our rights, and it will play a hugely significant role going forward as a globe addressing the climate crisis. And so I think the most important question moving forward, now that this has been launched, and it's something that the 196 states must incorporate into their policies and laws, is that how will governments implement and fulfill their commitments to the convention to ensure that our rights outlined in General Comment 26 are protected? And so I think that the importance of incorporating General Comment 26 is crucial. Obviously, all these stakeholders are now going to be held accountable. And I think that the comment outlines crucial elements required to uphold children's rights to a healthy environment in multiple areas, ranging from pollution to climate change. And for me, the most important message from General Comment that member states must recognize is that children are the future of our world. And we are the answer to solving the environmental issues that we face today. While enforcing environmental protection through children's rights, it is also creating a world that will be safe and healthy for children to enjoy in the future, once we are the future leaders, politicians, and scientists that are going to be making the decisions of the world. But we need to be living in a world that we can survive and live in and continue to protect, which is why General Comment 26 allows governments of today to ensure that they are starting to take action and protecting the world for us as we move into the future. And so while talking about General Comment 26, I want to particularly highlight a quote from David Boyd, who is the UN Special Rapporteur on Human Rights and the Environment. And so he said that this new General Comment marks a vital step forward in the recognition that every child on Earth has the right to live in a clean, healthy, and sustainable environment. Governments must now take urgent action to address the global environmental crisis in order to breathe life into these inspiring words. And so General Comment 26 specifies that states are not only responsible for protecting children's rights from immediate harm, but also for foreseeable violations of children's rights in the future due to states' acts or failures to act today. And so this is a specific aspect of General Comment 26 that I want to highlight, because by recognizing the rights of children to live in a healthy environment, member states are being held accountable for failing to fulfill and are responsible for violating these rights due to lack of urgency, because the lack of urgency with climate action by governments worldwide is already seeing prevalent effects globally. Many governments will say, we are going to aim to be carbon neutral, for example, by 2050, but in reality, 2050 is 27 years away, if my math is correct. And so leaving it that long, it's not going to allow us to actually reverse or prevent the impacts of climate change as much as we could if we started taking that action today, in my opinion. And so I think that by having General Comment for stakeholders to uphold, state members uphold, it ensures that the urgency of climate action is increased and people start to recognize that we need to start changing our ways, and we can't continue talking about taking climate action without actually, we need to put our words into action, is what I mean. And so as a young person from the Pacific, I grew up in Samoa until I was 14 years old. And so while talking about climate change, I think it's so important to also highlight how much it impacts children from a first-hand perspective, and not just looking at the General Comment 26, but also looking at it in the grassroots way that it will help children. Because from growing up in Samoa, the environmental the impacts of climate change in my home were very, very prevalent, are still prevalent today, obviously. And so while growing up, I have noticed the increase in temperature because, when I go back to go see my family, it's become so much more hot than usual. And the seasons have started to change and become more infrequent because we don't have our seasons go by the wet and dry season. And we've noticed the change in those seasons, although it's only slightly, there's still a change, and this is because of climate change. And we also have a huge problem of biodiversity loss, specifically in our oceans. And this is due to coral bleaching, but also due to the warming seas and lots of species migrating to colder waters. Because we're in a tropical area, the water is becoming even more hot than it typically is. And so this is a huge problem that we are facing, as well as the increase in natural disasters. I talked to my grandma who grew up in Samoa in the 1950s, and the amount of, she never saw cyclones or any sort of climate-induced event that to the same scale that I do, because in her lifetime, I think she's the most significant time of cyclones that she has seen has been in the 1990s and onwards. And so it just shows how much the climate has amplified in disasters. And I think it's just so crucial that seeing that this is such a huge problem will put it into context for people who are in these powerful positions to take action. And that's why General Comment comes as an incredible tool, because for young people of the Pacific, personally, I think that this is going to be a special tool that we can use to hold governments accountable for compromising our rights, because at the end of the day, these issues are going to continue to happen if we don't do anything about it, and not only continue to happen, but increase in severity. And so that can be seen in the increase in sea level rise as well. That's becoming more and more intense. And so we really need to take action before it becomes too late. And I believe that General Comment 26 plays a really, really significant role in moving this forward not only as a region, but also as a world. And so for young people of the Pacific today, I believe that General Comment 26 means that we are finally able to hold climate polluters accountable for their contribution to the climate crisis, which is directly felt across Pacific Islands. Because the Pacific is at the forefront of climate change and feels impacts most severely and disproportionately. And so, for example, our low-lying atolls such as Kiribati, Tokelau, and Tuvalu are already being lost to the sea because of sea level rise. And as I mentioned before, it isn't a problem that we can solve in 2050 because it is here and it is now. And while losing our islands means while losing our land means we're losing land that we could grow crops off of and live off of, there's so much more to it. And so the climate crisis doesn't only put losing our land at risk, but it means also losing our ancient indigenous connection to our land and our spiritual identity, our cultural practices, our history, and our belonging, because the land is so, so sacred to, in my understanding of my own cultures, it's so sacred to us as Pacific people. And I'm sure it's the same for lots of other cultures worldwide as well. And so once the land is lost, it can never be regained. And that's why General Comment 26 allows us to start taking urgent climate action. And with losing our land, this cannot be allowed to happen, because this means we're losing our livelihoods and our identity, our language, and everything that makes us who we are as people of the Pacific. And that's why young people of the Pacific have been calling for immediate and meaningful action. And we can see that these calls are starting to be heard by governments and politicians worldwide through these changes that they're making, for example, General Comment. And so that's why I think that General Comment 26 is a huge step forward to protect and preserve our islands, culture, and identity before it is too late. And so a quote that I really, really love and believe has so much power and holds so much weight is one by the Prime Minister of Tuvalu, Neleso Senyesopoanga, in his COP26 address. And he says that if we save Tuvalu, we save the world. And that's why, we as children of the world are calling on governments worldwide to step up and finally take responsibility and global action to fight the climate emergency. And GC26 is a powerful statement from the world's children. And so it's time for governments to now listen to our voices and finally take action. Yeah, Professor Lover, thank you.
Thank you very much, Aniva, for this presentation, and I'm sure we're going to hear more from you at a Q&A session. And hats off for you and to all the other young climate activists who led to this reform and led to this change. And Anne Scarleton, the chairman of the UN Committee on the Rights of the Child, I think was generous enough to acknowledge in her opening remark on Monday that it was children actions and children demonstrations around the world that motivated the committee to embark on this journey for almost 3 years of drafting a general comment about the rights of children and the environment. And it's certainly attributed directly to the actions of children and their demonstration and their political participation, which annoyed a lot of adults, including politicians. And we saw how politicians have reacted to these demonstrations in this country, in Australia, how they were quickly dismissed or mocked. And kids were sent back to school and were told not to bother adults in those important political processes and decision making. But it was young activists who pushed the envelope and led to the adoption of this very important document. And what I would like to do in my presentation is to say a few words about the content of general comment. So Aniva was very articulate in saying why it's so important and why we'll hopefully in the future will enable children and others to hold governments to account for their violation of child rights in the context of their environmental policies. And it's time now to say a few words about what this document might actually say and what sorts of obligations it imposes on states and the business sector, and how it frames it in the context of the UN Convention on the Rights of the Child. And the publication of this general comment, as Aniva was saying, it could not be more timely. Those of us who log from Sydney have experienced an unprecedented heat wave this week with temperature-breaking records for September. And the Bureau of Meteorology here in Australia predict that in nearly a summer, The Guardian, the newspaper, has published a shocking report just yesterday suggesting that Europe is facing, and I'm quoting, a severe public health crisis, with almost everyone across the continent living in areas with dangerous level of air pollution. And just this morning, Australia time, yesterday, New York time, the UN Secretary General, who opens the UN Climate Summit, attacked wealthy countries, saying that humanity has opened the gates to hell by allowing the climate crisis to worsen. So climate emergency has never been more real than today, and the general comment gives us a new framework to deal with the effects of climate crisis on the rights of children. And this is the main innovation of this general comment, is that it establishes under the UN Convention on the Rights of the Child, which is the most ratified UN human rights treaty of all, that children have the right to a clean, healthy, and sustainable environment. And state and corporations have various duties to protect and uphold the rights of children and future generations in this context. The general comment further sets out a framework for a child rights-based approach to environmental protection, addressing issues ranging from the rights of marginalized communities, indigenous communities, children who experience poverty, children who live with disabilities, and issues of access to justice in the context of environmental harm, and discuss in rather lengthy terms child rights measures that states must take in order to ensure that climate change mitigation and adaptation takes place. The committee emphasizes, and I'm quoting, the adverse effect of climate change on the enjoyment of child rights, and I'm continuing to quote, give rise to obligation of states to take actions to protect against those effects, end of quote. And the committee then adopts a holistic understanding of child rights as they apply to environmental protection. The general comment identifies children as agents in their own lives and emphasizing the importance of engaging with children in all matters concerning the environment. By extension, this means that children have a right to participate in drafting environmental policies and laws that will affect them. And the committee, as we just heard, attempted to set an example with that regard, and the general comment was developed after consulting with thousands of children and with establishing the Youth Advisory Board composed of 12 young people. And we are privileged to have Aniva with us today to say more about this process. Also, we saw an extensive involvement by states, IGOs, civil society, and others who have provided their input to into the process, and nearly 50 submissions that were made once the committee has published an initial draft of the general comment are available on the website that is now posted on the chat. And you can see in those submissions different views that were taken as to the rights of children in this context, with some states trying to minimize or downplay the importance of human rights and child rights protection in the context of climate change. And the most innovative element of the general comment, in my opinion, as I've mentioned it before, is the recognition of the right of children to a healthy and safe environment. The text of the convention does not explicitly mention this right, but nonetheless, the committee read it into the convention, mainly relying on the right to health under Article 24, the best interest principle in Article 3, and the right of the child to survival and development as protected in Article 6.2. The right to a healthy environment is then broken down to its substantive and procedural elements. The substantive elements the general comment suggests include the right to a clean air, a safe and stable climate, healthy ecosystem and biodiversity, safe and sufficient water, healthy and sustainable food, and non-toxic environment. The procedural element includes, for example, and I'm quoting, access to information, participation in decision-making, and child-friendly access to justice with effective remedies, end of quote. The committee identifies some immediate actions that states should take, including improving air quality by reducing both outdoor and household air pollution to prevent child mortality, especially among children under 5 years of age. It also at the same time stipulates some general steps that ought to be taken in order to conserve, protect, and restore biodiversity. And we've heard about the effects of biodiversity just now, or the lack of biodiversity, or the destruction of biodiversity. Aoife Nolan, professor of human rights law from Nottingham University, who was also a member of the Adults Advisory Board to the committee, which drafted helped draft the general comment, argued that the description of the immediate action that should be taken are slightly confusing, because on the one hand, the committee deems them as urgent, but on the other hand, suggests that implementation might take some time. For example, when the committee says that states should, and I'm quoting, phase out the use of coal, oil, and natural gas, ensure a fair and just transition of energy sources, and invest in renewable energy, energy storage, and energy efficiency to address the climate crisis, end of quote. And as such, Nolan argues, it will be a mistake to conceptualize this recommendation for immediate action and associated measures as amounting to immediate obligations in the sense that states having to ensure that they are to be achieved fully straight away. Instead, it seems that the committee expects states to take these steps immediately, even if their associated outcomes might be delayed. A lot of emphasis is put on Article 3 and the principle of the best interest of the child throughout the general comment. The document begins by reiterating the language of Article 3 and says that the best interest of the child shall be a primary consideration in all adoption and implementation of environmental decisions affecting children. This process then should take into account the specific circumstances that make children uniquely vulnerable in the environmental context. This uniqueness is based on the best scientific evidence that clearly show the long-term effects that climate change has on biodiversity, agriculture, the effect of rise of sea levels, and as a result, the ability to grow food, to live close to ocean or the sea, and at the same time also reinforces the image of children as inherently vulnerable and in need of protection. This image might stand in contradiction to the image of the competent child, the opposite image of the child as a competent person, an agent of their own rights. And indeed, the general comment emphasizes on a number of occasions the significance of recognizing children as right holders in the space of climate change. Highlighting the importance of respecting children as climate change warriors came after the committee itself has dismissed a communication from 16 children back in 2021, in a communication known as the Sachi case, where the committee decided that the communication from these children claiming that a number of state parties violated their rights due to their environmental policies was inadmissible. But at the same time, the committee made in that document 3 years ago some important comments about extraterritorial jurisdiction that the Convention on the Rights of the Child has, and it planted the seeds to the idea that the Convention, despite the lack of explicit language, protects the right of children to a healthy environment. In this context, the committee highlights the duty to rely on the best available science in making decisions about the environment, against a political reality where climate change deniers are in a position of power, and where some biased parties, like companies that contribute to, for example, air or water pollution, argue that their action have no adverse consequences, or that these consequences are minimal at best. Another important aspect of the general comment that I would like to focus on is Indigenous children and their communities, as they are deemed to be particularly vulnerable to climate change. The general comment says that states are obliged to ensure the right to life, survival, and development of Indigenous children, and that states are also expected to engage with Indigenous children and their families in responding to climate change by integrating, as appropriate, Indigenous culture and knowledge in mitigating and adaptation measures. And we heard from Aniva the experience of her family back in Samoa. This special focus should be a wake-up call to governments and a reminder that Indigenous knowledge, culture, and connection to the land should not be ignored, but rather appreciated when forming environmental policies, not only appreciated, but also informing the formation of environmental policies. And when engaging with indigenous communities, children of those communities should be heard and get the opportunity to participate in these processes too. Another important element is the call for government to require businesses to conduct due diligence of their practices, to assess how their current and future actions might affect the climate and the rights of children. This comes in addition to requiring businesses to take actions to reduce, for example, their carbon footprint and overall impact on the rights of children and future generations. Where the impact of a business cross national boundaries, governments are expected to ensure that businesses operate at, and I'm quoting, environmental standards aimed at protecting children's rights from climate-related harm cross borders. The comment also expects government to encourage investments in the use of zero carbon technologies, particularly when the assets are publicly owned or funded. Governments should also protect the rights of children when implementing tax regimes and procuring goods and serving from the private sector. So this is just few of the issues and new duties that states are under in accordance with this general comment, which now in turn can be used in litigation and in advocacy efforts. And one of the things that the committee has tried to do in this general comment is to write it in a language that will be easy to implement and easy to use. So not only for governments to clearly understand what their new duties are and what the committee expects them to do, but also that will enable advocates, adults and children alike, to use this document in their advocacy effort, in their litigation attempts. And I will finish with that. And now I would like to open the floor to everyone to make some comments or questions to either to myself or hopefully to Aniva as well. If anyone has any question, either raise your hand and we'll invite you to turn your mic on or pop them in the chat. And while you think about your questions, I might ask Aniva a question if you don't mind. And if you can tell us a bit more about the process of engaging with the committee. How did you end up being one of the 12 members of the advisory board? And how was the process of engaging in drafting a legal document, which I assume you weren't familiar with these sort of documents before?
Yeah, so the process in format for putting the children's advisory team together was through applying. So you had to apply to become a part of it. And so once the group came out, I think we first met last year, in the middle of last year, I believe. And so we've been working together for about a year, almost a year and a half now, as we come to the end of General Comment 26's formulation. And so it's been an amazing and incredible opportunity to work with the committee directly and getting to understand and learn about all their knowledge and their expertise within children's rights as well as environmental rights.
Thank you. And what sorts of introduction or knowledge were you given when you joined this advisory board, assuming that you weren't too familiar or not all participants were familiar with UN processes or with the convention and the role of the committee and the expectations, and what were the expectations from you? In that sense, what sorts of knowledge or views were you asked to provide, or were you given a free flow and you were able to take the work of the advisory committee to anywhere that you wanted them to be?
Yeah, so every single person in the advisory team do their own work within their own communities. And so that's how we're able to all bring that contrasting perspective and viewpoint depending on different regions that we come from and how climate change impacts us as young people in different ways. And so we've been mentored and helped with the supporting organization Terre des Hommes, and they have incredible staff and members of that organization that have supported us along the way with working with the committee and facilitating sessions for us to get to meet the committee, as well as talk to them about how climate change impacts us, and as sort of giving them a way to gain a more comprehensive understanding of how children's rights across the world are compromised in different regions from a youth perspective.
Okay, thank you. There are some questions at the chat, and thank you everyone for posting them. I'll take Fergus and Rebecca, and to some extent Charlotte, questions together in trying to see how this general comment might be utilized in the future. How it will affect state practice, I mean, time will tell. Some states have better track record in protecting human rights or changing their legislation and regulation in light of new general comments issued by the Committee on the Rights of the Child or other human rights, UN human rights committees. It's a question of political willingness and political capital and pressure that they will be under. And different states in that sense will react differently. And in that sense, activism in that space should not end at this stage, but rather take a different form. And young people and others can then utilize this established law, this general comment. It's a matter of soft law if you're taking a very strict, talking in very strict legal terms, but nonetheless, it's the authoritative view of the committee about the right of children in this space. And it can and should be used in advocacy effort locally and on the international level. And it certainly will carry weight within the UN human rights system, and in particular with the UN Committee on the Rights of the Child. And to Fergus' question, it can most certainly be used in direct communication. So the convention has an optional protocol, which about 50 countries around the world have joined to, which enables children and those who advocate on their behalf to submit direct communication to the committee, suggesting after exhausting all local remedies, states are still in the business of violating the rights in a specific context. And what children can do now, similar to what they did 3 years ago in the Sachi case that I've mentioned, is to argue that environmental policies are a violation of the rights under the convention. And in the Sachi case, the legal argument was centered around Article 3, 24, and 6. But now we can add another component, which is the explicit recognition of the right to a healthy and safe environment. And experience shows that when committees, including the Committee on the Rights of the Child, issues a new general comment, they usually have, in a span of 2 to 5 years, are more tuned to arguments around this new general comment. And you can see that as a cycle of the attention span. So the environmental issues have been in the committee's mind for a few years now, and you see that in the Sachi case, you see that in the concluding observations in recent years. But now for sure they will be more open to hear arguments about violation of general comment number 26. It will give advocates a framework to work with in making their environmental claim. At the same token, continue the questions that Charlotte have posted and addressing her question, it can be used in domestic court as well. And different legal systems give different weight to international law and to international human rights law, and the convention has been incorporated in different ways into domestic legislation. But even in countries where the convention is not applicable, or where there is less respect or engagement with international human rights law standards, the ways in which the committee has phrased the recognition in the right to a healthy environment, grounding it in known and recognized human rights like the best interest principle and the right to life, survival, and development, can help articulate legal arguments in different domestic contexts, which may recognize the same sets of rights under domestic constitution of Human Rights Act. And the best interest principle is a good currency and a good vehicle to make child rights claims in many countries. And in this way, the ways in which the General Comment engages with Article 3 and the best interest principle can also enable local advocacy efforts. Andre is asking about the effect that the General Comment might have helped with the case of Sharma and other similar cases. The case of Sharma, for those who are unfamiliar with this case, is a local case heard here in Australia, where Anjali Sharma and a group of children have petitioned the court against the federal environmental minister, arguing that in the process of licensing a new mining, their rights have been ignored. And this case was celebrated on first instance because on trial, the judge has found that indeed the minister has violated their rights under Australian law to exercise their duty of care to children when considering a new mining license. But unfortunately, on appeal, this decision was overturned. And on appeal, the judge has ruled that the environmental minister, in fact, has no duty of care towards children, and that their best interest should not be part of the consideration that the minister consider when exercising their authority under the law. There is now a campaign going on in the Senate trying to introduce an explicit duty of care into the legislation led by Anjali Sharma, and we'll see how that one flows. But back to the question of Andre, whether General Comment number 26 will have enabled or changed the outcome of this litigation, the best answer I can give is maybe. It can certainly give new ways to articulate the sort of argument that were made in that case. But the main challenge of Sharma and her colleagues in their legal action that they took was the lack of any meaningful human rights legislation here in Australia. So most of their case was using tort law language and duty of care that derives from tort law rather than from human rights law or from child law for that matter. And in that sense, articulating a new rights for children might carry less weight in our legal system comparing to other legal systems where there is better or more advanced or more comprehensive respect to human rights than here in Australia. And Claire has posted a number of links that gives more information about this case, including a webinar that we had with Anjali Sharma after the decision was given. Aniva, there is a question to you that James McDougall have posted. What would you like to do next as a result of your experience working with the committee?
Yeah, I think for me, next involves moving forward with climate action and climate activism. I want to go study law next year as I head into university. And so with working with the committee, I want to use that understanding and knowledge that I've gained from them, as I've talked about earlier, with the knowledge and information that they've shared with us to help support my studies, because I hope to one day work as an environmental and human rights lawyer. And so I think that working with the committee has really shown me that that's the direction I want to go, and it's provided me with lots of insight and finding my passion that is similar to theirs, which is children's rights and human rights, as well as environmental protection.
Thank you, Aniva, and good luck with your future law studies, legal studies. Hami from Nepal tells us that in Nepal, they are linking General Comment 12 that speaks about the right to participation of children and interpret the Article 12 of the Convention that speaks about the right to participation. And now General Comment 26 in discussing and demanding meaningful participation of children and young people in climate discourse. And it's often said that the right of participation of children is a vehicle to make change also in the political sphere. And once we enable children to engage and participate in these political processes, it will eventually lead to a better protection, a better engagement with their rights and with their point of view. And I think that this general comment and the process that Aniva has described to us in lengthy demonstrate the validity of this exercise and the need to engage with children in these processes and the utility of this process. It's not only that it improves the decision-making process, it also respects children from who they are. And what it does, it enables the committee and other decision makers to get the perspective of children and of young generations. And this is another innovation of the general comment, which we didn't spend too much time discussing. But what the committee have said is that the convention protects not only the rights, or should be used to protect not only the rights of concrete children, and Aniva is soon to be above the age of 18, and therefore will lose the protection the convention provides for children, but it also should be used to protect the rights and interests of future generation. The general comment doesn't say much about this element, and it's part of an ongoing discourse in human rights scholarship about the rights of future generations. But in that sense, the committee now opens the door for future developments in this space and future utilization of the Convention on the Rights of the Child in meeting the rights and interests of future children and future generations, and establishing contemporary and concrete steps that states should take at the present time in order to protect the rights of the unborn, of future generations. The unborn as a generational issue rather than the unborn as concrete unborn children. Any other question that someone would like to address, either to myself or to Aniva, or other comments that someone would like to make in this context? Andre is asking Aniva, following off the numbers that you provided and saying that we had 12 children part of the advisory board, but more than 15,000 children engage in different consultation processes that the committee and the NGO assisting it has run throughout the years. And the question is, do you have any suggestion for increasing this number and how it can be done?
Yeah, I think that we had a huge amount of children participate because, you know, over 16,000 young people is a huge contrast of voices, especially when you look at the numbers of a number of different countries that they come from, which is 120 different countries. But I think that in order to increase this, the tool that we use to get as many as we did at the time was through social media, I think most significantly, as well as networks that various people within that were working with the committee and working on general comment had. And so I think that to increase this number for future projects, I think, is the power of social media. And although but the problem that does arise with social media at the same time is that a lot of young people won't be on social media or won't have the access to the internet, depending on their situations. And I think that is a crucial aspect when it comes to doing consultations online, is that there are people that don't have the opportunities or resources to be able to participate in these activities. And that's why I think that face-to-face consultations are really important as well, which is what the committee and the Children's Advisory Team did through General Comment 26 as well.
Thank you, Aniva. And indeed, social media, on the one hand, enables to reach out to more communities and more children, but at the same time, we should recognize, as Aniva was saying, that there is a still issue of access, and not everyone has access due to technological issues, to socioeconomic background, and language barriers that can prevent people from engaging with these international processes. I assume that this process happened in English, which may or may not be the language that the child speaks, and translation is costly, and there is an issue of resources. That's another element. The committee is an underfunded and under-resourced body, and these consultation processes, especially if you need to be on the ground and speak with children face to face, this is something that costs a lot of money. In international bodies or domestic bodies, and we should not forget that the same obligation to engage with children and to enable them to participate in these processes is now an explicit duty of government as well. So they should spend time thinking of how they engage with different children from different communities in their jurisdictions, and using social media, it might be seen as the easy answer, but it's not necessarily the magic bullet. There's a question from Anthony here that speaks about a case that he doesn't remember, or she doesn't remember the explicit details, that speaks about the future generation. The question is, how persuasive is that internationally, and more specifically to Australia? And again, this is a question of how you phrase this argument. And I've said that there is an ongoing discussion in legal scholarship about the rights of future generations and what sort of obligation it imposes on different duty bearers, in our case, state parties. And in the general comment, the committee explicitly made the reference to the rights of future generation, but it didn't stipulate much as to how it might look like and what sorts of obligations it entails. It was satisfied by saying that climate policies, contemporary climate policies, might compromise the right of future generations and might create an adverse effect on the ability of future children to enjoy their rights, especially the rights to life, survival, and development, and to a healthy and to a adequate standard of living under Article 27. But it didn't say much as to what sort of obligations it asks to impose on states. So this is an area of law that still is underdeveloped, and therefore it's underutilized. Any other questions or comments that someone wants to make as we are coming to an end? If that's the case, we will thank Aniva Clark for her participation in this webinar. Thank you very much for taking your time to be with us today and to share your experiences with all of us. Thank you all for signing up and joining into this webinar. This is, as I said, one of 3 webinars that we are planning to have discussing various elements of the new general comment about the rights of children in the context of the environment. I would like to thank Andrei Frankovich and Claire Sidotti from the Diplomacy Training Program who made this webinar possible, and to all of you who joined us and who are watching us online. And that's it. Thank you very much. Have a good afternoon or a good day, wherever you are.